When earlier this year we received the invitation to participate in this large World Law Congress here in Barranquilla in December, honestly, I had some doubts as to whether the Congress can take place with hundreds or thousands of participants. As Konrad Adenauer Foundation, and this is the organization that I'm representing, the Rule of Law Program Latin America, we've organized for decades seminars and large conferences on current legal topics. To name only one recent example, the latest edition of our annual meeting of tribunals, courts, and constitutional courts of chambers Latin America, the 26th edition, had to be cancelled in 2020. In June 2021, it took place, but only in virtual format. Therefore, I'm truly glad this Congress can be held in a hybrid manner, with the participation of hundreds of experts, many in presence and some more speakers online. Now, when discussing with Rainer Arnold what topics we would address for a debate, it became clear swiftly that we could not avoid discussing the emergency measures. Therefore, in this panel today and in several following ones, discussion will center on emergency responses during the pandemic and how or whether they have protected fundamental rights. Before swiftly opening the debate, let me just say that I'm glad that our panel and the following ones managed to bridge several world regions with the participation of a number of experts from more than one continent. In this first panel, we will hear speakers from Germany, Slovenia, Poland, Italy, Ukraine, Romania, Brazil, and Uruguay. And Spain, I'm sorry. In the second, also from Poland, Peru, Colombia, the host country, Moldova, Slovakia, Chile, Lithuania, and many others. Therefore, I am sure by the end of these discussions, we will get an accurate picture of how states have dealt with the recent legal challenges. We will hear mainly from European and Latin American legal responses to the pandemic. But now, it is a delight for me to represent my co-moderator for this panel, Professor Rainer Arnold of the University of Regensburg, Germany, who, among many other functions, is Professor for Public Law, Comparative Law, European Law, and is the holder of the Jean Monnet Chair of European Law. Professor, you have the floor.
Thank you very much, dear Mr. Rank, dear colleagues, dear participants. First of all, I really want to thank the Konrad Adenauer Foundation for helping us so voluntarily, and they supported us financially in a very large way, and I'm very thankful for them. And Mr. Hartmut Rank is the director of the Latin America Rule of Law program of the Konrad Adenauer Foundation, and to him and his collaborators, I want really to address my deep thankfulness. And let me now very shortly present our participants here in presence and online. So you know that the World Congress is a Congress of the world, and for this the time is always too limited. For we saw this, the opening session has got a part of our time, but of course we had to concede this, but now we are a bit in a time trouble, and you know, first of all, that there is a rule, not the rule of law, but the rule of 7 minutes for the speeches. Well, I apologize for that, but this is a requirement from the organization. And let me say also that all the panelists, the full text will be published, so you have an opportunity to express your opinion and to analyze the situation in your country. Well, first speaker will be Professor Matej Accetto. He is the Vice President, Deputy President of the Constitutional Court of Slovenia and the President-elect. And in these coming days, he will start with his new function. And I'm very happy that he has accepted our invitation. Then I want to welcome also Mr. Chief Justice of the Supreme Court of Estonia, Villu Kõve, and this is very important. Supreme Courts, well, we have constitutional courts according to the model of Kelsen, but also Supreme Courts, and a department of your court is also examining laws, and rule of law is, of course, a top subject and top issue also I suppose, in your court. Well, then here I have Professor Ania Rytel, and Professor Ania Rytel is Professor of Public Law, Constitutional Law at the University of Gdansk in Poland. And since long we have been working together, and I'm very happy that she has come to us. Then I welcome Professor Viktor Mouraviov. Professor Viktor Mouraviov is a professor at the Taras Shevchenko University of Kiev. And so thank you, dear Viktor, for coming. As well as Professor Natalia Mushak from Kiev as well. We are very glad that you have dared to go into this adventure to come to Barranquilla, so far away from Kiev. Then I want to welcome Professor Luca Mezzetti from University of Bologna, the director of the School of Judges there, and with very straight connections also to Colombia. Then I want to welcome online Professor Elena Simina Tănăsescu. She is judge at the Constitutional Court of Romania and a professor at the Bucharest University. So welcome also online. Thank you so much. Then I welcome also Professor Casimiro Navarro Ojeda from the Las Palmas University Las Palmas de Gran Canaria, a constitutionalist there, and annually I have the pleasure to teach constitutional law in his lectures, and what is very pleasant, not only from the side of science, but also from geographic side. It's not so maybe Caribbean, but it's very nice nevertheless. So I would also like that Mr. Rank will welcome Madam Monia Hennig.
Yes, we have not mentioned yet Professor Hennig from Brazil, from the University of Rio do Sul, who is also a member of the Konrad Adenauer Study Group of Constitutional Law. Excuse me for a very brief presentation, but we would like all the experts to give time enough to do their presentation. So therefore, with Professor Hennig, we are concluding that panel. The other speaker who is announced from Uruguay cannot speak at the panel today. Thank you.
So now I think we can give the floor to the first speaker. This is President Matej Accetto. Take the floor, please. Yes, you are here, Matej.
Hello. Just use yours. Okay. So I see I'm already half a minute behind. So thank you, chairs, for the introduction. In the interest of time, I will try to make my remarks brief as well. COVID, as you well know, has posed a number of challenges, and for the constitutional jurisprudence, to summarize them in very simplistic ways, it's two challenges in particular. One is the fact that it poses a severe threat for a very substantial, important subset of fundamental rights dealing with the protection of health and life of individuals. But on the other hand, the challenge of the uncertainty, not just as to the nature and the severity of the threat posed by the virus, and nowadays ever more so the variants of this virus, but also on the effectiveness and the wider implications of the measures contemplated to combat it. So necessity to act in the face of uncertainty seems to have introduced a sort of a dilemma, a difficult choice between effective measures to contain the epidemic and adherence to the traditional standards of the rule of law. I firmly believe this is a false dilemma, but it has been presented, portrayed, understood as such by some. In contrast, I believe very much that the adherence to the established principles of the rule of law should allow for the accommodation, the management, the coordination of the response to COVID. One way of doing so is, of course, to declare the state of emergency, familiar to a lot of the constitutional regimes, including the Slovenian one. But the Slovenian experience has been one where the government has chosen not to declare a state of emergency. So the questions posed in Slovenia have been whether in the ordinary state of affairs there are reasons to depart from the established standards of judicial review, allowing for a less strict judicial scrutiny because of the exceptional circumstances of the COVID epidemic. And I will mention just two remarks, two elements, areas where the court has been mindful of these circumstances. One is the principle of legality. In Slovenian constitutional regime, the limitations of the rights may only be prescribed by law. But as was apparent in many countries around the world, the existing legislation at the onset of the epidemic have been inadequate, have been wanting in terms of addressing the scope, the nature, right, the breadth of the implications of the epidemic. And partly because of the political, the delicate political climate with a very divided parliament, in Slovenia many of these measures have been introduced by bylaws, by governmental decrees, rather than by ameliorating, bolstering the legislation and the legal basis. Now, the court has been mindful of that, and in particular when reviewing the first measures after the start of the epidemic, we have said that there is a reason to depart from the strong adherence to the principle of legality in a very small sense, namely that when there is a need for swift action, the swift adoption of the measures, and also swift amendment of the measures as circumstances dictate, it is not necessary that the legislation really deals with the details of how these limitations are to take place, and that inferior legislation is possible to take over that role, but that even in such cases, the law should provide a very clear framework detailing the scope of the limitations that are possible, the purpose of these limitations, and the criteria to take into account on the format, the methods of introducing these limitations through inferior legislation. And in the Slovenian experience, I'm abbreviating the several hundred cases, some of which have resulted in decisions on the merits. We have found that decisions often to be wanting, or sometimes to be wanting in this regard, the measures adopted by the government. Now, the second element is proportionality. The idea that because of the uncertainty, it is difficult to ascertain whether the limitations are offset by the benefits to the legitimate aims pursued. And there is a call for some appreciation, some further margin of appreciation to be given to the authorities when implementing these measures. And the court has agreed, but noting very much that there are three additional criteria which are indispensable if such limitations are to be deemed proportionate nevertheless. The first, that they are based on scientific advice, scientific suggestions on the measures to be introduced, of course based on the best available information and knowledge at the time. Second, that they are very clearly delimited in terms of temporal validity. And third, that they're accompanied by a very clear and transparent information dissemination, which states very clearly the reasons for the measures being introduced to the addressees, the individuals concerned. With those three, I think we have very clearly divided sometimes in assessing particular measures according to those criteria, but the court has largely accepted them. And let me just finish. As you see, these are very brief snapshots, right, of the practice. Let me just finish by reiterating what I said before. I think it is very much a false dilemma, and our practice, I hope, confirms that, as we will look at it retroactively, that you should actually depart from the precepts of the rule of law to safeguard or to adopt measures combating the COVID. I think that it has shown, our practice, I believe, has shown that it is precisely by adhering to the rule of law principles that appropriate measures may be introduced to safeguard long-term an effective response to COVID, and that, the last sentence, the rule of law actually, by the test of COVID, should have been seen as being reaffirmed rather than emasculated. Thank you very much.
Thank you very much, dear Mr. President, dear Matej. Very clear, and this reminds me, of course, of our German situation. 2 days ago, our Federal Constitutional Court has confirmed the urgency measures which are based on the traditional mechanisms, and also proportionality and legality and transparency. Also, this plays a role very, very similar to what you've said. We have in our constitution now, let's say, emergency situation. We go on with the traditional mechanisms, but they must be very proudly used. And this, thank you. So I give the floor, but of course, yes, you are not bound by my my predeterminations. But please, Mr. Chief Justice.
Thank you very much, Mr. Chair. I want to share my thoughts about this situation and Estonian lessons on coronavirus and some challenges that are important to us. There are not so many cases in Estonian Constitutional Court as the Supreme Court is acting. Not yet, but there are many cases pending in the low instance courts and different challenges they are, and we still have more questions than we have answers yet. But what we have seen, what the lessons of coronavirus are, this epidemic, that no one knows exactly how long does it last, that when it will be under control more or less. That means we don't know how long these restrictions will stay with us that were introduced. And let's hope that the effective vaccination and the spatial cure are good for it. But there was like a competition between the different countries to introduce even more and even stricter restrictions to prevent the outbreaks of virus and to make its consequences less hard. At least the states closed the borders, the movement of the people was blocked, international solidarity was almost forgotten at one point. In European, we could see that the European Union was stopped, almost dead at one point. That was terrifying something. Judiciary stopped in many countries in Europe, but no one really knows how the restrictions really work. We can compare our two neighboring countries, Estonia and Latvia. We are both in the north of Europe. Latvia has 1 or 2 months ago introduced very strict corona measures, prohibited that every kind of activities, and we don't. But the figures were the same in Estonia and Latvia, almost the same. We were on the top, on the peak, and after that the numbers are lowing down. Today's situation is similar in both countries. That means that there can be, that the virus as well, it's on its own. It seems to be that the strict measures are not working better than more liberal measures. For me, this was terrifying how easy people were ready gave up their rights and freedoms in this time. And even demanding it. Freedom we spent years of even centuries fighting for. And my biggest concern is, can the same scenario be repeated for other purposes by the governments when it is so easy? And there is common understanding that the person's liberty is always limited by rights of other people. And in certain situations, however, freedom can be highly restricted, even illusory. It has touched on free movement, gathering, interaction, work and holidays, even on personal integrity, and indeed on the freedom to say and think, to believe and to act accordingly. The emergency situation has changed our understanding of freedom, democracy, the role of science, believing in something, tolerance and solidarity. We can only be guided by professionals in the fields at the time, and the opinion of experts are so important that the big decisions were made on the basis of them. But this is huge responsibility for them shoulder, and no one knows exactly what will be outcome. It is some responsibility basically possible to make for making the wrong decisions. One point is that many people were, let's say, they were under the influence of the social media, and so much false information is given that the question is, can we somehow restrict the freedom of speech? In Estonia, where the people were always very peaceful, and no one is demonstrating for almost 10 or 15 years. We had demonstrations this autumn. Thousands of people are demonstrating against the corona measures, the vaccination, the face mask duty. That is, although in Estonia the measures are quite liberal, in most countries are most stricter measures as we have. But people are somehow against it, and we think now about how we can manage the situation, and what are the main questions, I think, today for our constitutional review. The first one and the main question is, can we introduce the compulsory vaccination, and with what consequences? Can we just restrict the accessibility of social services, fire non-vaccinated people, ask money back for the treatment in hospitals, or introduce fines, or even physically compulsory vaccination? How far can we go with every kind of other restriction, with test requirement, where it is needed really, or just a measure to motivate people to vaccinate? How can every kind of measures be implemented formally? Do we need the emergency situation? It is correct that the measures were implemented by the government, as is in our country. But if government agrees, and the parliament is off from decision-making process. Can we restrict the freedom of speech, especially in social media, to spread the conspiracy theories? Who will decide it? How far can we restrict the people's right to access justice? Right to oral hearing before court in corona time, especially defend rights in criminal cases? Or the right to receive the judgment in reasonable time, or to make an appellation to the court's decision? Can there be responsibility for implementing too strict measures without sufficient ground, or to give a wrong opinion on the basis of restriction, or to call people not follow the government decision, especially politicians, or by the social media? These are the basic questions at the moment in our society. I believe it is similar to the situation of other countries. Of course, every country can have the special problems too, but this is our experience. Thank you for listening. I'm just in time.
Thank you. Thank you very much, Mr. Chief Justice, for this clear picture of Estonian situation, which is rather similar, of course, in principal issues to other systems. And we have transnationally the role of social media and what they are spreading out in part. what is against science or against also acceptance by the society of these real necessary measures. Thank you so much. Now I give the floor to Professor Ania Rytel from Gdansk University.
Thank you very much. Thank you very much. When it comes to coronavirus crisis in Poland, I think that I could just repeat what my colleagues said, because this is quite similar and global problems that we have to face. So I would like to refer the topic of our panel, Emergency, Fundamental Rights and Rule of Law, to a little bit different context, to another emergency that we have to face in Europe, and Poland particularly. So this is the situation of the constitutional review and the Constitutional Court. So Constitutional Court is at the moment, especially in countries that suffered from the communist regime in the past, not only a guarantor of the Constitution, but also the guarantor of fundamental rights, and this is very important. So at the moment we've got a wave of illiberal constitutionalism in Europe, and it means that, for example, in Poland, the Constitutional Tribunal as such is quite paralyzed, so the government does not respect the judgments. There are some violations of the procedures concerning the appointment of judges and the president of the Constitutional Court and so on. So as a result, the Constitutional Court cannot fulfill this function, very important for citizens, and we are just looking for some alternative ways to provide it. And the discussion led to one solution. So we are just thinking about the possibility of common courts to decide on the unconstitutionality of law during the process of its application. It's worth to mention that in the past, in Poland, in the 90s, it was quite clearly discussed, and it was decided, agreed, that common courts in Poland cannot refuse to apply law because they think that it is unconstitutional. If they think so, they should suspend the case and just refer it to the Constitutional Court. So it was not questioned, it was commonly accepted. However, in the face of the crisis, constitutional crisis that we had to rethink that approach, and in two last years, the doctrinal opinions on the admissibility of judicial review has evolved considerably, so the doctrine of law in great majority now agrees that courts can not to apply law if they find it unconstitutional under certain circumstances. And these are the provisions, these circumstances include first, that the provisions in question cannot be reconciled with the Constitution by applying pro-constitutional interpretation. The constitutionality of the norm has not been subject to judgments of the Constitutional Court so far. But there is also the third one that is called the Doctrine of Necessity. So this is the situation, the condition, that it is impossible to obtain a fair judgment from the Constitutional Court. So we have the situation that the extraordinary situation of constitutional crisis has somehow influenced or determined even the way of interpreting the Constitution, and the courts has now the right which they were denied before. So I think that it is problematic, and it posed the question of how far the emergency situation, it can be constitutional crisis, but it also can be the COVID crisis, can justify the changes in the approach to the constitutional interpretation, and how this newly developed doctrine of necessity can affect the constitutional reality after the crisis. So on the one hand, it helps to overcome the critical situation at the moment, and it contributes to the protection of constitutional rights. But on the other hand, it can also create a dangerous practice that may be abused in the future. So this is the question we have to answer, yes, how we will apply what we do now with what will we do with these extraordinary measures we apply now towards COVID crisis or constitutional crisis in the future? Yeah, so thank you.
Thank you very much, dear Ania. Here we see that constitutional justice and, of course, legal scrutiny and evaluation under constitutional aspects of emergency situations, how closely they are connected, and that, as we also heard, that the emergency situations as pandemic, they challenge rule of law and also the legality and constitutionality of the measures, but nevertheless they are also, let's say, a yardstick for seeing is rule of law efficient or not. So these situations brings up some points. Is a system of constitutional justice, is this efficient or not, or where are the deficiencies, or where are the advantages? And so we see that the pandemic gets or makes clear even deficiency or crucial issues in the legal order as such. Well, thank you so much. And now I give the floor to Professor Mouraviov from Taras Shevchenko University of Kiev. Dear Viktor, please take the floor.
Okay. Now it works. Thank you very much. After such a long flight and these unpleasant but maybe proportionate COVID restriction, it is a great pleasure to see you again here, healthy and happy. And vielen Dank an unseren Freund und wunderbaren Menschen, Professor Rainer Arnold, für diese seltene Gelegenheit, das Land der Smaragde zu besuchen. Vielen Dank an die Adenauer Stiftung and World Law Congress für die hervorragende Organisation unseres Kongresses. I would like to speak about the development of the rule of law concept by the constitutional justice. In my opinion, the future of the mankind to a large extent will be dependent not only on our fight against coronavirus, but also on who will prevail in the confrontation between democracies and authoritarianisms. Therefore, the rule of law is forming a threshold that separates democratic societies from authoritarian societies. Rule of law is a common heritage of mankind. It was born in ancient organized society. Today, the notion of the rule of law, or Rechtsstaat, État de droit, appears as a main feature of the state in all European democracies. It can be mostly found in preambles or other general provisions of European constitutions. At the same time, it looks like that legal provisions referring to the rule of law, both at national and international level, are of a very general character and do not define the concept in much detail. This has led to doubting the very usefulness of addressing the rule of law as a practical legal concept. However, it is increasingly included in national and international legal texts and case law, especially the case law of the European Court of Human Rights. Many scholars believe that the rule of law does constitute a fundamental and common European standard to guide and constrain the exchange of democratic exercise of democratic power. According to Professor Reiner, rule of law, Professor Arnold Reiner, rule of law is a fundamental principle of constitutionalism. Rule of law establishes legal basis for functioning of states and international unions. At the same time, the rule of law is supposed to be judicially guaranteed primarily by constitutional courts. The Venice Commission tried to solve problems related to the definition of elements of the rule of law. In 2016, the Venice Commission adopted the rule of law checklist. In accordance with this document, the rule of law is linked not only to human rights, but also to democracy, that is, to the third basic value of Council of Europe. Professor Reiner Arnold underscored that modern rule of law, at least in the continental European sense, is essentially based on the primacy of the Constitution, in particular on the constitutionality of legislation judicially guaranteed, as well as by its value orientation. Dignity and fundamental rights are constituent elements of the rule of law. Legality of executive action has been complemented by legislative constitutionality. The people's will as the basis of democracy is expressed by the law which people create through their representatives in parliament or by direct vote. Taking into account the wide meaning of this notion, we can speak about two main dimensions of the rule of law at the European Union level. The internal dimension of the European Union and member states and external dimension of this concept. The EU Court of Justice developed the rule of law concept at the EU level. In the case Parti Écologiste Les Verts, the European Parliament, the EU Court of Justice stated that the community is based on the rule of law inasmuch as neither its members nor its institutions can avoid a review of the question whether the measure adopted by them are in conformity with the basic constitutional chapter, the treaty. The constitutional charter, the treaty, with the EU Court of Justice recognized that the EC treaty is a EU constitution and it should be judicially protected, as well as the common values enshrined in it. That is, the rule of law connotes judicial review of the European legislation. The external dimension means the application of the rule of law value in the external relations of the European Union towards third countries, for instance, in the association agreements. And to conclude, I would like to stress that although the different systems of law offer somewhat different interpretation of the concept, the rule of law should be distinguished from the purely formal perception that any action of officials prescribed by law are considered to meet the requirement of the rule of law. A challenge for the future is how the achievements of the rule of law can be preserved and further developed under circumstances where individuals are increasingly influenced by and linked to new modes of government. Thank you very much.
Thank you, dear Viktor. Yes, you have also opened the dogmatic side of rule of law, and of course in all these countries where rule of law is a weapon, let's say, or a defense instrument against excessive emergency measures which are not conform to constitutionality, it is very important to have a look also on the dogmatic side. Thank you so much. Now I give the floor to Professor Luca Mezzetti from Bologna University.
Thank you, Rainer, for giving me the floor. Thank you very much to the Konrad Adenauer Stiftung for the invitation, and to Professor Rainer to join me this panel. Italy has suffered the strongest impact of coronavirus in Western Europe. We had till now 150,000 died people, more than 5 million people that have suffered the coronavirus. And why I am mentioning this data? Because for us it was a very strong situation that needed a shocking answer, shocking solution. So an emergency solution. Unfortunately, the Italian constitution, if compared, for instance, with the German or the Spanish one, does not dedicate any chapter or any provision to emergency situations, apart from Article 78, where emergency powers of the government are mentioned following the declaration of the state of war by the parliament, but no more provision on emergencies or état de siège, situations. So it is true that Article 16 of the Constitution on the freedom of circulation, freedom of movement, allows restrictions by statute, by a statute, not by decrees of that freedom. But during the pandemic situation, it was a first very strong problem. The government declared a state of emergency based only on the code of on the emergency of about natural emergencies. So a very large interpretation of the possibility to declare a state of emergency, and according to that state of emergency declaration, starting already from February 2020, the government started to issue decrees, so administrative decrees of the president of the government, so government decrees, administrative ones, that according to our system are not to be submitted to the constitutional judicial review of the Constitutional Court. So I see two main problems starting from these considerations. First, according to this terrible pandemic, the task, the very important task of constitutional lawyers, not only Italian ones, should be to study the opportunity of introduce in constitutions, and our constitution for sure, provisions concerning not only war emergencies or public order emergencies, but also health emergencies. The second one is that the rule of law suffered a very strong violation, I think. Why? Because the government tried to regulate the emergency not through a law decree that in our system has the same force of statutes of parliament, but through a precedent of government decrees with no basis on a law, with no basis on a statute. It is also true that in more recent times, at the beginning of this year, the government issued a law decree concerning the pandemic emergency, allowing the government itself to issue decrees. And this law decree was converted into law by the parliament. So now the government power to issue decrees has a legal foundation, has a legal basis. But I continue to share severe doubts about the procedure. In any case, the Constitutional Court of Italy, in quite recent times, 2 months ago, has declared that this practice of government decrees to manage the emergency health situation is constitutionally speaking, is according to the Constitution. This is why, this because, say the Constitutional Court, these decrees now find their legal basis on a statute that converted a law decree. So a very complicated situation that creates very interesting problems for the constitutional lawyers and very interesting tasks for every one of us to deep the problems arising from coronavirus emergency. Thank you very much.
Thank you, dear Luca. Here, well, we see that there is an ex post constitutionalization in forms of emergency measures taken before, maybe not quite in conformity with procedural rules. So thank you. Now, yes, I give the floor to Natalia Mushak, also requesting and asking for demand for how to say, for the favor that we can extend. We a bit go into the time of the second level, but it seems maybe we can have a compromise by that. No? Yeah. Dear Natalia, please, have the floor.
Thank you very much. Dear colleagues, dear friends, firstly, I would like to thank you to Professor Reiner for the invitation, to Konrad Adenauer Foundation for the maintenance and for the opportunity to make the report. Just in regard of brief and short presentation, I would like to focus just only key problems in regard of human rights restrictions in Ukraine. Human rights are heritage of any mankind, but the degree of its guarantee and protection depends on any democratic society. Human rights, especially constitutional rights, they are not absolute because of their implementation could be restricted strictly by law. It is allowed, of course, in the interest of human rights protection in order to protect territorial integrity and also impartiality of justice. In particular, the situation with COVID-19 in Ukraine beginning from March 2020, Ukraine adopts a lot of, almost 15 bylaws in order to prevent COVID-19. But I'd like to emphasize that these quarantine restrictions were adopted by bylaws, not laws of Ukraine. Just it were the resolutions of the Cabinet of Ministers of Ukraine, the decrees of President of Ukraine, but not the laws of the Verkhovna Rada of Ukraine as a legislative body of Ukraine. That is why, to clarify this situation, it's the most important to indicate that all human rights and all the restrictions on human rights have been adopted just in regard of the protection of the rule of law. In order to implement and to decide, resolve the situation, the Supreme Court of Ukraine applied to the Constitutional Court of Ukraine to explain these inconsistencies. Just a year ago, it was on the 28th of August 2020, the Constitutional Court of Ukraine delivered the judgment. In accordance with case, it was the statement that under the Constitution of Ukraine, only under Article 64, we have only 2 cases of restrictions of human rights, in case of state emergency and in martial law. Also, I would like to focus and to stress that in Ukraine there wasn't any state emergency or state emergency situation. Despite of this, all the fundamental rights have been violated. I mean, the restrictions were concerned of the freedom of movement, the freedom of strike, the right to work, the right to education, and so on. So what is the most important? That these restrictions, I mean in Ukraine, were just incompliable with the Constitution of Ukraine, and they do not correspond to the principle of rule of law. The second situation regards and concerns the martial law, that I must admit that beginning from 24th of August 1991, from the independence of Ukraine, just Ukraine faces only once and adopted and introduced the martial law. It happened 3 years ago, just only for 1 month. It was from 26th of November till 26th of December 2018. It just was in regard of the aggression of the Russian Federation on the eastern part of Ukraine and the annexation of the Crimea Peninsula. That is why all the restrictions of fundamental rights, they were adopted in regard and in conformity with the law of Ukraine on the special regime of the martial law. So what is the most important, and what is the most important from legal point of view? That it's highly strict to distinguish between restrictions of human rights and violations of human rights. In regard of the temporary occupied territories in the eastern part of Ukraine, the rights of those people who are still residing in these eastern territories, they just not been restricted, but they have been violated. And in accordance with the law of Ukraine of 2015, the responsibilities, the main responsibility of all the violations of human rights is on the Russian Federation. Just to sum up, what about these main restrictions of fundamental human rights and freedoms? The first point, that in regard of the COVID-19, all the epidemic situation, all the restrictions were adopted with non-compliance with the Constitution of Ukraine, and it was stipulated by the judgment of the Constitutional Court of Ukraine. The second point is that the most important, that in regard of the Article 64 of the Constitution of Ukraine, the martial law was introduced not throughout all the territory of Ukraine, but only in 10 of 25 regions in Ukraine, and the rights there have been violated. And the third, the last point, what is the most important? To distinguish the restrictions of human rights and the violations of human rights. And the main responsibility just on the occupied the Russian Federation in against of war crime in Ukraine. Thank you very much.
Thank you, dear Natalia. This, restriction and violation, of course, this question is always very relevant in examining constitutionality of emergency measures. So you demonstrated this on well-known examples, and of course, the discussion on how or in which mode fundamental rights can be restricted, legality, proportionality, the maintenance of the essence of the fundamental right, this also comes up, and thank you so much. Now, I know that we have now Elena Tanasescu as an online participant. We would like not to disappoint the panelists who are not in this wonderful city of Barranquilla, but at home in cold weather, so we should really ask them, and I apologize for that, but it is a certain emergency situation also as to time, but we will see. That is good. How can we do? We have to connect with Elena, with Professor Tanasescu, and she has a link. She told me, she wrote me yesterday. So we need a Tanasescu. It is. She's. Oh yes. So I. Dear Elena Simina, thank you. Welcome to the Caribbean region in Colombia. So please take the floor. Yes, Yes, we hear. Yeah. Or.
Allow me to thank the organizers of this Congress for inviting me to present the PANELISTS facility to my participation online, which is not easy, and I'm very grateful for that. Today I was asked to present the way in which the Romanian Constitution report dealt with the pandemic while granting human rights. From the outset, I have to say that I'm sure that the recipe we use in Romania is not through cooperation and consultation, balancing the constitutional protection of the values of the values protected by the law is not new. Like many other constitutions, the Romanian one equally protects public health as public interest and fundamental rights. And it is the role of the Constitutional Court to make sure that the legislature has properly managed these values. Also, like other constitutions, the Romanian one makes a provision, because Articles of Association, which provides for the recipients criteria and the conditions for restricting exercise and not touching them with substance of the public use. If this can only be done in order to protect, among others, public health. If this can only be done, is really necessary in a democratic society in a non-discriminatory manner, and by remaining the decision is proportionate with the cause. Now, having said this, and to accept the general background, now that Romania has also gone through some of the stages that were already presented by previous speakers. In Slovenia, the COVID pandemic has been dealt with as a national security, as a threat to the national security. So it made also a martial law, a state of emergency. That was considered an exceptional non-military event endangering the life or health of the person. So it affected a state of alert. And it was finally considered as a pandemic that required sanitary measures. For instance, this map, the 60 days of state of emergency, was immediately placed with strong restrictions to their rights. During a very short transition period, 2 days, there was a state of alert that was violating the restrictions. And it's only starting with June 2020 that we have a specific state of alert, which is regulated through a law adopted by Parliament. All along these various exceptional situations, the Constitutional Court protected the fundamental rights. In some cases, the Constitutional Court allowed fundamental rights to prevail and declared unconstitutional measures meant to protect public health. In other instances, it did the contrary. The very first decision that the Constitutional Court, the Romanian Constitutional Court, had to adopt, it encapsulates the entire debate that continued over almost 2 years now. It's also interesting that it is also interesting because it is based upon a majority and a separate opinion that actually present how the interpretation of these various state of emergencies could be approached. According to the majority opinion, legal formalism obliged the court to know that the legal regime of the state of emergency was fixed through an act of legislative delegation and not through a law adopted by Parliament. This has been deemed sufficient to declare all measures adopted as unconstitutional, but not based on a substantive review, rather based on extrinsic formal review, because legislative delegation cannot restrict fundamental rights, according to another article of the Constitution. The majority opinion was also satisfied to know that a normally active whose object is a crisis situation negatively affects and restricts the exercise of fundamental rights because its very aim is to create a legal framework necessary for exceptional measures. So the majority judges simply accepted restrictions to the fundamental rights during exceptional situations, but they consider that these exceptions cannot be imposed through legislative delegation. According to the minority opinion, compliance with Article 53 of the Constitution cannot be verified through a review which is aiming at another article of the Constitution. According to this minority approach, whether the restriction is imposed by an act of Parliament or by a legislative delegation, it doesn't change the situation with respect to the restriction of the fundamental rights. The review performed by the court still has to be a substantive one in order to truly check whether the restrictions were constitutional. It is interesting to note that the formalistic approach has been favored by the court later on in only one other decision, and the minority opinion was actually became the majority one in all the remaining decisions. This also had some consequences, but I'm fully aware of the distance and difficulties, and I'm again very grateful for being allowed to make this presentation in that distance. I would like just to conclude. The main conclusion that can be drawn from the previous presentation is the fact that in Romania, the debate regarding the protection of fundamental rights during the COVID pandemic was focused on the respect and interpretation of one article of the Constitution. I consider this to be a solid illustration of the fact that during all the states of exception, the emergencies that have been used during the COVID-19 pandemic in Romania, they were all considered as mere derogations from the general framework of the rule of law, and not as a lawlessness and simply martial law imposed from the outside. And I take it as a positive note to end with that. Thank you very much again for your attention.
Thank you very much, Professor Tănăsescu. We will now cross the Atlantic and come to Latin America, and I immediately would like to invite another online expert here present at the panel, Professor Monia Hennig, to share with us the Brazilian perspective. Professor, you have the floor. I'm asking the technical experts for help. We have another expert connected on Zoom. Necesitamos? Yes, we can hear you, but we cannot see you yet. Hello?
Yeah, I can hear you, but...
Yes, now we do see you. Thank you.
Thank you. So, thank you for the invitation. It's a pleasure to share this panel with all of you. And I'm trying to compare the situation of Brazil in Spanish. Dos situaciones de estado de defensa. Pasando situaciones de inestabilidad institucional. Y un último, pasando de la calamidad de la naturaleza de grandes proporciones. La introducción de hipótesis de perfecciones o suspensão de derechos está relacionada con el estado de sitio que es indicado en el salamento para situaciones de insuficiencia del estado de defensa o en caso de declaración de guerra. ¿Pueden escuchar? Pero no me ven.
Sí, podemos, pero no lo ven.
Bueno, ¿sigo hablando? Bueno. Así que tenemos dos situaciones con testigo específico de derechos que pueden producir suspensión, asociando la idea de temporalidad y de efectividad de la interpretación de esas situaciones. Y en el caso de ella, no se ha computado ni la declaración del estado de defensa y tampoco el estado de Estado. Así que se ha mantenido en Brasil la prevalencia de la presunción del Estado de Derecho y de las reglas de la Constitución. La única excepcionalidad que se ha planteado en términos de protección de derechos fundamentales, específicamente, por ejemplo, en términos de protección de datos, que se ha intentado un decreto por parte del presidente para compartir datos de las empresas de telefonía móvil para adoptar medidas de combate a la pandemia. Y el Supremo Tribunal Federal ha considerado que la medida no incorporaba la necesidad de temporalidad, de especificación del uso de los datos y por lo tanto violaba a los derechos fundamentales y al derecho fundamental a la protección de los datos. También aspectos importantes respecto al derecho a la información que me parecen interesantes. Se ha intentado suspender las medidas y los instrumentos de acceso a la información durante el periodo de la pandemia, y el Supremo Tribunal Federal se ha pronunciado de que especialmente en tiempos excepcionales y en tiempos tan difíciles hay que reforzarse el acceso a la información y el deber por parte de las autoridades públicas de prestar cuentas, de rendir cuentas y de tratar de manera muy abierta los gastos públicos y las medidas que se están tomando. También respecto al acceso a la información sobre los datos de la pandemia, que el presidente ha cambiado la manera de cálculo y de divulgación de los datos a lo largo del proceso, y eso ha dificultado para hacer la comparación y tener una real situación de los números que se tenía en el país, que fueron muy drásticos. Y también se ha pronunciado el Supremo Tribunal Federal sobre la obligación de seguir manteniendo la forma de cálculo para que se tenga una visión clara de la evolución de la pandemia. Un otro aspecto, también en términos de implementación de derechos, se ha producido sentencia específica, una sentencia estructural respecto a la creación de un plan de enfrentamiento de la pandemia para los indígenas, y así que el Supremo Tribunal Federal ha hecho un control muy fuerte, establecido criterios muy estrictos de organización y de establecimiento de este plan, reconociendo incluso el derecho al aislamiento de los pueblos indígenas y la posibilidad de que accedan a un sistema de salud que respete a sus particularidades culturales y así por delante. También la prohibición de realización de acciones militares durante la pandemia en las favelas, y también la prohibición de despejo, de retirada de las personas de sus casas durante el periodo de la pandemia. Unos aspectos que me parece que es importante destacar es que el Supremo Tribunal Federal siempre se ha pautado por el aspecto de adopción del principio de proporcionalidad, de adoptar la exigencia de justificación respecto a la restricción de los derechos fundamentales, y ha utilizado verdaderamente el principio de proporcionalidad para invalidar las medidas adoptadas, incorporando unos aspectos y reforzando unas ideas que me parecen interesantes, especialmente en lo que dice respecto a la necesidad de observancia de los datos técnicos y de las orientaciones de los órganos calificados para hacer orientaciones y recomendaciones, así como la Organización Mundial de Salud, para la adopción de las medidas restrictivas. Así que el Supremo Tribunal Federal ha reconocido el derecho a la salud, un peso grande al derecho a la salud, pero las restricciones a los derechos fundamentales deben darse con base en datos estadísticos y en base de datos concretos basados en aspectos científicos que justifiquen la restricción y la relación de finalidad y las medidas adoptadas. Y también ha dejado muy claro que la pandemia y el escenario todo no justifica medidas o atropellos, y eso hay que reforzarse, por lo tanto, la observancia del debido proceso legal, la observancia del Estado de Derecho y la manutención de los derechos fundamentales en ese proceso. Así que la urgencia no justifica la adopción de determinadas medidas. creo que así findo mi exposición reiterando que el Supremo Tribunal Federal verdaderamente en un escenario complejo en términos políticos, de enfrentamiento, incluso creo que el principal problema que hemos tenido en Brasil fue un embate entre el Poder Ejecutivo y el Poder Judicial, una cierta disputa, pero verdaderamente un protagonismo del Supremo Tribunal Federal y del Poder Judicial en la garantía de los derechos fundamentales en el contexto de la pandemia, específicamente en una situación de no haber una suspensión oficial de los derechos. Muchas gracias.
Muchas gracias de nuestro lado también por la descripción de uno de los desafíos en ese periodo en Brasil. Tenemos otro experto.
Muchas gracias. Ahora, no sé si es posible conectarse con el profesor Casimiro Navarro, porque estamos retrasados. ¿Es posible?
Sí, estoy conectado.
Momento. Is he here?
Sí, estoy conectado.
Buenas tardes.
Buenas tardes,
Casimiro.
Buenas tardes a todos
un
los
poco,
colombianos y ponentes.
2 minutos solamente.
Intentaré ser breve.
Porque
señor Rytel.
estamos muy retrasados. Espera el panel. 2 segundos. No, por favor. Ok.
Vale, intentaré ser breve. Buenas tardes a todos nuestros hermanos iberoamericanos y colombianos. A la vez que deseo darles el agradecimiento más profundo a los organizadores de este fenomenal congreso por el acierto en su organización y a la vez por su invitación y confianza depositada en mi persona. A la vez que le envío un cordial saludo al profesor y amigo Arnold desde Canarias. Y es que todo Estado de Derecho, la emergencia y el estado de alarma tiene un carácter estructural de las sociedades contemporáneas, que marca una frontera indefinida, delgada e indefinida, que en muchos supuestos son imperceptibles en el derecho y la anarquía o de gobierno, ya que siempre crea un conflicto entre libertad y libertinaje, o entre seguridad y de gobierno, y entre justicia o caos social, que deja patente en muchas ocasiones lesionada o tocada el objetivo último de toda sociedad, como es el fin común y la paz social. De un análisis comparado y transversal de los estados de excepción a través de una aproximación desde el derecho constitucional europeo, se ha podido constatar la inexistencia de un modelo común con respecto a las condiciones y a los supuestos de hechos que legitiman la declaración de los estados de alarma o emergencia y el límite del ejercicio de los poderes públicos. Entre los estados que recogen sus constituciones, los estados de excepción, el panorama es sin duda muy variado. Algunos estados, como Alemania y España, han recogido en sus constituciones vigentes un verdadero derecho de excepción, presentando un marco constitucional muy bien ordenado y garantista, no solo con respecto a los supuestos que pueden dar lugar a los estados de excepción, sino también con respecto al procedimiento para la proclamación y gestión y a los instrumentos de control y garantía de los derechos fundamentales. Por otro lado, tampoco existe uniformidad en los mecanismos de control y de garantía del ejercicio de los poderes públicos en los estados de excepción y se constata una fuerte incidencia de las tradiciones constitucionales y de los acontecimientos que han caracterizado la historia constitucional de cada estado. Sin embargo, a pesar de las profundas diferencias formales entre los distintos modelos, un punto de conexión se puede encontrar por un lado y desde un plano sustancial en los principios fundamentales, recogidos en el Convenio Europeo de los Derechos Humanos y en los demás obligaciones normativas de carácter internacional, que derivan de los tratados internacionales ratificados por los Estados de la Unión Europea. Y, por otro lado, y desde un plano más bien jurisdiccional, en la actividad del Tribunal Europeo de Derechos Humanos y de las jurisdicciones nacionales, tanto las ordinarias como las constitucionales. Y en particular no debemos de obviar que las cartas magnas, en cuanto a ley fundamental, y esencial de todo Estado democrático, debería asumir el papel de guardián de los derechos fundamentales ante los posibles arbitrios procedentes de los poderes públicos y de sus regulaciones con los poderes económicos. Y termino, ya que me han pedido brevedad, ya que he de dejar patente que un derecho de excepción o una constitución de emergencia a nivel europeo permitiría responder ágilmente al conjunto de situaciones que determina una fractura en el orden jurídico, poniendo en peligro su permanencia y los principios fundamentales de las constituciones democráticas, como es imponer límites a un ejercicio unilateral y arbitrario del poder público, en detrimento de los derechos y libertades fundamentales de las personas. Establecer estándares mínimos, uniformes, de tutela de los derechos y libertades fundamentales y de las medidas comunes para una intervención conjunta y ágil de la Unión Europea y de camino permitir reforzar la legitimación y el sentido de Estado de la Unión, la cual actuaría unida para salvaguardar los intereses fundamentales de los Estados miembros. Termino porque me han pedido brevedad y a todos nuestros hermanos iberoamericanos un cordial saludo desde Canarias, España. Muchas gracias.
Muchas gracias, Casimiro. Muy interesante, pero ahora me disculpo para el panel 2, pero no es estado de emergencia general aquí. Now I want to thank all the panelists and all the participants here to our first panel, and I have the proposal that you continue, and maybe after you have finished we can maybe have a common discussion, or I would say, but you should, and yes, I am, how to say, désolé that you have lost so much time, but it was not possible, of course, to shorten who was waiting outside and to say, no, you cannot speak. And but I hope that it will go on. You have now a good time, and I'm sure your panelists are also very, as ours, very strict in time, and we have a good instrument here, that's fine. I think you should come up here, I think all the panelists, and then let us make this change. Okay, thank you.